Picture this. You wake up, grab your coffee, and boom, you are walking into a massive corporate disaster. You're completely blindsided, millions of dollars on the line, and your entire company's survival is hanging by a thread. And the craziest part? It's all because of a few tiny words buried deep in a contract. Today, in this explainer, we're looking at the ultimate legal safety nets, or sometimes the lack thereof, in corporate contracting. Let's get right into it. So let's say a vendor accidentally spills some toxic chemicals at a company's warehouse. It is a complete, utter environmental nightmare. The immediate cleanup cost, 2 crores. But oh, it doesn't stop there. The angry neighbors whose properties were affected sue the company for another 10 crores. That is a devastating 12-crore disaster just sitting right there on the company's desk. Naturally, the company rightfully tries to make the vendor pay for the huge disaster they caused. But here is the absolute shocker. Because of one tiny, seemingly harmless clause hidden in their contract, the vendor only had to pay 50,000 rupees. Yep, you heard that right. The company was left holding the bag for the rest and went completely bankrupt. So how on earth did this happen? Well, it happened because the buyer fundamentally did not understand two absolutely critical concepts: indemnity and limitation of liability. Okay, let's dive into this and break down exactly what went wrong. In simple terms, indemnity is your ultimate legal shield. It's basically a legally binding promise where the vendor says, hey, if my mistake causes a third party to sue you, I will step in, I will fight the lawsuit, and I will pay all the damages for you. When you have a strong indemnity clause, you are protected from the fallout of their errors. But then we have the other side of the coin, right? Limitation of liability, or LOL. And this acts as a strict financial cap. It's the clause where the vendor essentially says, look, no matter how badly I mess up, the absolute maximum amount of money I will ever pay you is X. So if indemnity is your legal shield, limitation of liability acts as the vendor's strict financial ceiling. And this brilliantly illustrates the dynamic if we use an everyday analogy we all know, car insurance. Think of indemnity as the car insurance itself. If you accidentally smash into someone's fence, your insurance company steps in, deals with the angry homeowner, and pays for the fence so you don't get dragged into court. But limitation of liability is your policy limit. If you cause 10 lakhs in damage, but your policy explicitly caps out at 2 lakhs, well, the insurance company pays their 2 lakhs and walks away. You have to pay the remaining 8 lakhs out of your own pocket. Let's see how this actually plays out in a real workplace scenario. Consider this cautionary tale about a manager. Let's call her Ria, over at XYZ Limited. So Ria hires an IT vendor to manage customer data. The total value of the contract is a seemingly harmless 5 lakh rupees. Honestly, it looks like standard everyday procurement. Nothing to worry about, right? But disaster strikes. The vendor makes a terrible mistake and accidentally leaks the private data of 1 million customers right onto the open internet. Naturally, the angry customers sue XYZ Limited for 50 crores. Now, because Ria included a strong indemnity clause, the vendor is legally responsible for paying those customers. However, the vendor smartly snaked a limitation of liability clause into the fine print, capping their total maximum penalty at the value of the contract, which, remember, was just 5 lakhs. So the vendor hands Ria 5 lakh rupees and just walks away. XYZ Limited is left paying a 49.95 crore nightmare literally out of their own pocket. Now, what's really interesting about this slide is it totally busts a massive point of confusion. Beginners constantly think these two clauses do the exact same thing, but in reality, they are actively fighting against each other. Indemnity determines who takes the blame and pays the third party. It protects the buyer. Limitation of liability determines the maximum amount they can be forced to pay. It protects the vendor. One gives you a shield. The other puts a ceiling on how much that shield can actually block. So knowing what to look out for is absolutely crucial. And this brings us to the ultimate auditor's red flag, what we call capping the uncappable. Auditors are basically hunting for lazy contracting by buyers who allow vendors to put a financial cap on everything. It is a massive, critical risk to the business, and it happens way more often than you'd think. You must firmly understand this golden rule. In corporate law, you should never accept a limitation of liability for gross negligence, willful misconduct, or intellectual property theft. Basically, if a vendor intentionally commits fraud or breaks the law, you absolutely cannot let them hide behind a financial cap. Their financial liability in those specific cases must be completely, absolutely unlimited. To wrap this up rapidly, Indemnity is your shield, and limitation of liability is the vendor's ceiling. Understanding exactly how these two forces interact is quite literally the difference between surviving a crisis and going completely bankrupt. Which leaves us with a pretty critical question for your own contracts. If your vendor caused a massive disaster tomorrow, do you know exactly where your shield ends and their ceiling begins? Think about that for a second. And I'll see you in our next explainer where we're going to tackle exactly how to negotiate those caps to keep your company bulletproof.